For motion, item number 1.
Yes.
Your Lordship, I am the counsel for the petitioner in this writ petition, and the essence of this writ petition is that the petitioners are given an LSC in the year 1985, which has been cancelled by the respondent in 2026 after taking taxes from them until 2026.
When it was cancelled?
Cancellation was on 12 to 2026.
12 to 2026.
And moreover, there is another thing. The National Highway project for the upgradation and widening the petitioner's land have been acquired by the Kala.
It is already acquired or what?
Yeah, it is already acquired, and 3G notification has already been established, valuing the land, only the asset value, not even the land value, around 13 lakhs, 49,375. Therefore,
Though you are claiming for this compensation of more than 13 lakhs for your acquisition of the land,
yes,
but presently your ownership or your LSC has been cancelled.
yes, that is correct.
Yes.
So therefore, Your Lordship, I pray an immediate and interim stay on the operation of the cancellation.
Yes, who is appearing here? From government side? You are representing the respondent numbers?
4, 5, 6, and 7.
4, 5, 6, and 7. And you are representing? 1. Yes, he is also praying for interim, as an interim stay of the order. But want to say anything? Do you have any submission in that regard? Now, how it can be a stay? It has already been passed. Cancellation is already there.
Yes, my lord.
So let notice be served at this stage. Let us see if you're going to submit anything. You are Mr.
David Mulsomkima.
Heard Mr. David Malasong, the learned counsel for the petition, and also heard MS Jer Songpi the learned CGC for the respondent number 1, and MS and additional. You are a government advocate or additional?
Government advocate.
Government advocate appearing for the respondent number 4, 5, 6, and 7. How many private respondents at the National Highway Authority is anyone representing? 2 and 3. And the Highway Authority. Also heard Mr. So-and-so, the learned counsel, appearing for the respondent number 2 and 3, the National Highway Authority. And 7 you are representing that. So all respondents have been represented.
Yes,
All
my lord.
respondents have been represented. I think. Full stop. This is an application under Article 226 of Constitution of India for issuance of writ in nature of certiorari for quashing of the impugned cancellation order dated 12
Lordship, I am appearing on behalf of the respondents 4, 6, and 7.
4, 6, and 7 only.
Yes, my lord. Oops. Oops.
And the 5 you are not appearing? Okay. Take it a 4, 6, and 7. So and so. Cancellation order dated 12/02/2026. And also file a petition for issuing of writ of mandamus for assessment and disbursement of the full compensation. It is submitted by Mr. So-and-so, the learned counsel for the petitioner, that the petitioner was granted with LSC of W19 in 1985, and since then the petitioners are in possession of the so-and-so, but after 50 years of this LSC, it has been cancelled by the impugned order dated 12/02/2026 on the pretext of dormant 1965 forest notification. He further submitted that the National Highway Authority has already acquired the land of the present petitioner, and till date they have not. There is no payment of compensation, which amounting to rupees 13,49,375. Mr. So-and-so, the learned counsel for the petitioner, accordingly prayed for the stay of the order of cancellation dated 12/02/2026. Issue notice to the all respondents. Next paragraph. However, no notice, formal notice is required to be served on respondent number 1, 2, 3, 4, 6, and 7, as the government council and or the state council has already represented the respondents. However, notice may be issued to the respondent number 5 through the registered AD and as usual process. Do you want to submit any written affidavit in opposition?
Yes, my lord.
Further, considering this submission made by learned counsel for the respondents, how many weeks you need?
3 weeks time.
3 weeks. No. Considering so and so, the 3 weeks time is granted for filing their filing their affidavit in opposition, if any. List the matter accordingly after 3 weeks as on a date to be fixed by the registry. Okay, it will be listed after 3 weeks.
Thank you, Lordship.
Item number 2.
May it please your lordship. My lord, by filing this writ petition, we have challenged the persistent inactions of the respondent authorities on their failure to comply to compensate the petitioner for the damage that has been caused to his land. The facts of the case is that, my lord, the respondent number 5 had constructed a retaining wall on top of the pre-existing retaining wall of the petitioner. So the respondent number 5 is the contractor under the supervision of the respondent number 4, that is the NHIDCL, and the building is situated along the National Highway 105B at Kliapui village.
But how damage was caused to your land? Because
My lord, may I take-
submitted that one existing wall was already there.
Yes, my lord. That is constructed by the petitioner himself within his land, my lord.
Within your land.
Within my land, my lord. Yes. And may I take your lordship to the annexure 4, the photographs, my lord.
Page?
Page 20 to 23. Excuse me. Due to the said construction, my lord, the egress and ingress of the house of the petitioner has been greatly hampered. And page 23, if you may I take your lordship to page 23. At the second picture, my lord, due to the heavy slabs of the retaining wall, the pre-existing retaining wall has collapsed, and the petitioner, despite submitting a representation to the concerned authorities, there has not been any fruitful positive remarks from the respondent authorities till date. So, having no other alternative, my lord, we have approached this honorable court, and this honorable court has passed a similar order. A coordinate bench of this court has passed a similar order that is annexed at page 26, annexure 6. My lord, the relevant portion would be at page 28. May I read, my lord? In view of the consent of the parties, this court is of the view that a verification team should be constituted. Accordingly, the Secretary to the Government of Mizoram, Land Revenue and Settlement Department shall constitute a verification team consisting of the District Collector cum Deputy Commissioner Kolasip or his representatives, the Deputy Chief Engineer Construction NF Railway Silchar Assam or his representatives, and the petitioner, who shall verify the lands of the petitioner within a period of 1 month from the date of receipt of a copy of this order. The verification team consisting of the above persons shall verify whether the lands of the petitioner have been used by the respondent number 2 for constructing a road. If the answer to the above is found to be in the affirmative, the respondent number 2 shall immediately take a decision within 2 weeks from the date of the said verification as to whether they want to permanently acquire the lands. If the answer is in the affirmative, they shall make a requisition to the respondent number 1 and 3 for acquisition of the lands. Thereafter, award shall be made as per the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 within a further period of 2 months.
Yes, anything to submit? There are Union of India, most probably you are representing, no? So you are representing 1 and 2 also?
My lord, I am for respondent number 1. My lord, the petitioner herein claimed the mesh. Then he is not maintainable. He has to approach the civil court. That is my submission, my lord.
Yes, yes.
Second.
My lord, in that case, my lord, may I make one statement regarding that. The disputed question of facts can be entertained by the writ court. And other than that, my lord, at the present, there is no disputed question of fact. Because,
Why disputed question of facts?
because my lord, the construction has been undertaken by the respondent authorities. Rightly or wrongly, my lord, if I'm not mistaken, there might be an agreement between the respondent number 4, the contractor, and the ministry. So partly the only issue that can be decided is the liability in that regard. And I have an authority here, my lord. I'll just read the relevant portion, my lord. In an appropriate case, the writ court has jurisdiction to entertain a writ petition involving disputed question of facts, and there is no absolute bar in regard thereto. A writ petition involving serious disputed questions of facts, which requires consideration of evidence which is not on record, will not normally be entertained under Article 226. However, it has even been held that in a writ petition, if the facts require, oral evidence can be taken. So where disputed questions of facts pertaining to the interpretation, meaning of documents or parts thereof are involved, the courts can very well go into the same and decide the objections if facts permit.
Okay, but otherwise it seems that there are disputed questions of facts and you can very well approach the civil court. Because your private land there is a damage in the private land due to construction of so and so by the respondent number 5, the contractor.
Well,
So anyway, if they want to submit any written objection or affidavit here? or outrightly it can be heard and decided. Okay, we can hear the matter on the next week, next date then. So you are representing the only 1 and 2. Who is representing it by 2? You are representing 2.
Lordship, I am appearing for the respondent number 2.
2. And the National Highway Authority you are representing. Heard Mr. Nalro Punga Pauti, the learned counsel for the petitioner, and also heard learned CGC, the learned appearing for the respondent number 1, and MS so and so, the learned government advocate appearing for the respondent number 2, and the respondent number. You are representing 3 also, no?
No, my lord.
And the respondent number 4 is represented by Mr. So-and-so, the learned counsel for the National Highway Authority. Learned standing counsel for the National Highway Authority. Full stop. This writ petition has been filed for non-payment of compensation towards the damages of the land of the petitioner which had occurred due to construction of a retaining wall within the petitioner's land at Liapui village, so and so district, Mizoram, undertaken by the respondent authorities. It is next by, it is submitted by Mr. So and so, the learned counsel for the petitioner, that after acquisition of the land for the construction of National Highway, the one retaining wall has been constructed inside the boundary of the present petitioner, causing damage to his landed property without providing any compensation to the people. In that context, MS so and so, the learned AG, learned CGC submitted that it is a matter question of determination of facts is involved in this, disputed facts is involved in this case, and hence this writ petition may not be entertained at this stage, and the petitioner can approach the civil court at the civil court. In that context, Mr. So-and-so, the learned counsel for the petitioner, citing a decision of Honorable Appellate Court, has cited that the writ court also had the authority to determine the disputed question of facts in certain circumstances. Considering this submission made by learned counsel for both sides, let notice be issued to all the respondents. However, no formal notice is required to be served on respondent number 1, 2, and 4. As full stop, the copies of the relevant copies may be served during the course of the day. Further, the petitioner is hereby directed to take steps on the respondent number 3 and 5 to restart AD and usual process. Full stop. Let the matter be accordingly listed after 3 weeks, enabling the respondent side to file their affidavit in opposition if listed accordingly.
My lord, may I? Thus, stay may be permitted to the respondent number 5 if lordship permits. Steps through thus stay may be permitted to respondent number 5.
Okay, considering the submission made by learned counsel for the petitioner, prayer for dusty service of notice on the respondent number 5 is also allowed. The affidavit will be filed to that regard on the next date of listing.
I'm obliged.
Item number 3.
May it please, my lord.
So you have paid already the
We've deposited the,
cost?
yes, my lord.
Deposited.
In all the 3 matters, my lord. 3, 4, and 5.
Total 30,000.
Yes, my lord. And now the main appeal is coming up for the first time, my lord.
You are representing how many respondents are there as a whole?
Altogether 37, my lord.
37 respondents.
Yes, my lord. And we are yet to serve a copy of the main appeal, my lord.
You are representing whom?
Your Lordship, I'm appearing on behalf of my senior, Mr. Bignunga.
For whom? For whom?
For respondent,
All respondents?
yes, Lordship.
1 to 37.
Yes, Lordship.
All the private respondents.
Only private respondents. Is there any comment? Only private respondents are there, I think.
Yes, my lord. If notice is issued, we can serve them a copy of the appeal, my lord.
They have already appeared as most probably in the
IA.
IA they were appearing.
Yes, my lord.
Okay. Hard Mr. Samuel, Delarned. You are appearing as a strength of
Additional AG, my lord.
additional AG. Additional AG. Asa nahi to naam to ha side of Mr. So and so Delarned additional AG for the appellant. And also how you are Mr.
Somdong Zela Tilum.
So and so appearing on behalf of, you are appearing on behalf of whom?
Mr. Bignunga.
Mr.
Bignunga Namta.
Nam to side over there. So and so. For all the private respondents number 1 to 37. Next, where this appeal has come for the first time after the compliance of the order passed in IA
29/1/2026.
in IA Civil
17.
17/2025, whereby the cost of rupees 30,000 in all the LA appeals has already been submitted by the respondents. Issue notice to all the respondents. However, full stop, no formal notice is required to be served to the respondents number 1 to 37 as they have already entered into evidence. But copy of the appeal memo of appeal may be served during the course of the day. Let the matter accordingly be listed in admission column. After 3 weeks we'll do.
Yes, my lord.
After 3 weeks as on a date to be fixed by the registry. Okay.
Obliged, my lord.
Item number 4.
4 and 5 is similar, my lord. Same order, my lord. Say that, please.
কিন্তু আগতে মই ৰেছপণ্ডেণ্টে দিয়া বুলি ক'লো যে পইচাটো এপেলেণ্টেহে দিছে দেই ৰেছপণ্ডেণ্ট চেম দিব হাৰ্ড মিষ্টাৰ চেমুৱেল সোয়েনছো ডিলাৰ্নেট এডিশ্যনেল এজি 4 and 5 একেই হা ফৰ দি state appellants from the office note dated 30/03/2026. 30. You are appearing here?
Yes, my lord, in item number 4.
Yes, yes. Oh, item number 4.
Yes, my lord.
3 to teket koriba, 4 teket koriba. So and so. This is 4. This is 4. This is 3. You are appearing in which item?
In item number 4.
আচ্ছা 4ত এখেত এপিয়াৰ কৰিছে হা আৰু 5ত আগৰ যিজন আছিলে সেইজনে এপিয়াৰ কৰিছে নামবিলাক দিয়া আছে 5 and 5 which we are appealing you are আচ্ছা তেখেতে 5ত কৰিছে এখেতে 4ত কৰিছে আচ্ছা ঠিক as per office note dated 30/03/2026 4 হ'ব the appellant has already deposited rupees 10,000 imposed by this court in order dated 29/01/2026 passed in IAC Bill 21/2025 and in connected 3 appeals they have already filed they have already furnished rupees 30,000 in total. Accordingly, the appeal has come before this court for the first time. You are appealing for whom? All.
Yes, my lord.
How many private respondents are here?
33.
33, Lordship.
Huh?
33.
33. Again, আগৰ অৰ্ডাৰটো হৈছে 33 কাৰণ তেওঁলোকে appeal কৰিছে. So notice দিব নালাগে খালি during the course of the day papers to be. আৰু 5টো same 5টোৰ আপোনাৰ এইটো অফিচত একে 30/03/2026 খালি IAC বিলটো হৈছে 34/2020 otherwise both the 3 matters 3 4 and 5 are almost most probably similar in all the matters the appellant has already submitted the cost which has been imposed in the RSIC so we will issue notice no formal notice is required we are listing these matters after 3 weeks as on a date to be fixed by the rest. In the meantime, if you want to submit any affidavit in opposition, you can.
Yes, Lordship. Oblige.
Item number 6.
My lord, lower court reports have been received and the registry may be directed to prepare paper book at the expense of the appellant. Normally, expenditures is borne by the appellant.
You want a paper book here?
Paper book, yes, my lord.
In the meantime,
Otherwise, we have received the case record, I think.
Case
Not
we got
the
already
record.
received, my lord.
my lord, in the meantime, the appeal is not yet admitted. So let's have a proper admission hearing. In maybe posted again for admission hearing.
But here,
This is can appeal.
no, but this is
Well-
this is RSA. But whether
RSA,
any
yes.
substantial question of law, etc., already
That
been
has-
formulated.
We have already formulated and the same was submitted and it is reflected in the court order dated 4/7/2025, my lord.
4/7.
4/7/2025.
So the substantial question of law has already been formulated.
No, my lord, this is only the proposed substantial question of law.
Post.
Proposed substantial question of law by my opponent. It is not yet
Now,
admitted.
see, the question is that in a RSA, if suppose for the admission of the RSA itself, it's required that there should be some substantial question of law. If substantial question of law are not at all there, in that case, it may not be admitted also. But here we have seen that they are already formulated by the court.
No, formulated. This is a proposal only made by my learned senior counsel.
Acha, acha, oh, these are proposed substantial.
Yes, yes.
Oh, acha, acha. acha.
My lord, whatever the case it may be, our duty, my duty is to submit the proposed substantial question of law.
No, no, yes, yes.
And the Honorable Court also has taken cognizance of it, and the same was reflected in the court order. So what we can do now is to give direction to the registry to prepare a paper book so that we can have a proper admission hearing also as well. Admission hearing as well as final hearing, my lord, on the basis of the substantial question of law proposed by me, by the appellant. No harm done if it is prepared.
Preparation of a paper book will not cause anything
Yes,
just to you.
okay,
That
ma'am.
can be prepared. I can understand these are only the proposed this substantial question of law, but till that there is no admission and the case is not admitted under some substantial question that has not been formulated by the court. I can understand. So let it be on admission hearing. In the meantime, paper book can be
May be
prepared.
prepared. Yes, my lord.
Heard Mr. L.H. Lian Hirima, Lilanit's senior advocate. You are assisted by?
My assisted by Ruth Lalruth Feli.
আচ্ছা ওই আগৰ অৰ্ডাৰটো আছে 47 অৰ্ডাৰটোত assisted by 47 যেটো অৰ্ডাৰ আছে তাতে আছে লিখা
It is in the cause list, my lord.
yes yes in the cause list also yes কোনটো আছে জানে cause listৰ নামটো নাই ও আছে cause listৰ নামটো আছে চাই লব advocate assisted by Mr. Ruth Lindiwala so and so the counsel for the appellant and also heard you are Mr.
J.H. Ramne Moya.
J.H. so and so Tilani counsel for the respondents. Full stop. It is submitted by Mr. Lian Rima that Dylan senior advocate that the trial court record has already been received and hence the registry may be directed accordingly to prepare the paper book and the matter may be listed for admission hearing. Next para, Mr. so and so Dylan counsel for the respondent submitted in this regard that by the order dated 4/7/2025, the court had discussed the proposed substantial question of law by the appellant, but till that the appellant is not admitted on the basis of any substantial question of law. Accordingly, he also submitted that the matter may be listed for admission hearing. Next para, considering this submission made by Lani counsel for both sides, the registry is hereby directed to prepare the paper book for convenience of both the parties as well as for the court. In the meantime, the matter may be listed for admission hearing. As on how many weeks you need? After 3 weeks or 2
My lord,
weeks?
the matter
It will
may be
take
put
some
up
time.
as and when the
Okay.
paper book is ready, my lord.
The registry is also directed to list the matter immediately after preparation of the paper book.
My lord.
List accordingly. Oh.
Obliged.
Item 7 through 9.
Mayor, please, your lordship.
Yes.
Your lordship, the humble landowners are before your lordship praying for modifications of the judgment on 2 counts as per provisions of law, my lord. Modification as per provisions of law, my lord. If my lord may kindly come to the impugned order which was passed, that is, the relevant portion will be found in page 28. Just after the index, we have placed the impugned order, my lord.
28. 28.
My lord, page 28, my lord. Correct. It's Roman number, page 28.
28 means.
Then that was the conclusions of the.
Annexure. Hey, page 28. Annexure
My
1
lord,
or what
the
is
impugned judgment is just after the index. No, it's the impugned order which we have placed just after the index.
Just
So-
after the index.
Yes, just after the index, we have placed
Index के बाद
the
में
impugned order.
impugned order just after the index. Wait a second. Dated 17/12/2024.
My lord, my lord.
17/12/2000.
Just after.
Wait, pull a dictator. No, the order was passed by additional district and session judge as all.
Correct, my lord. Fellowship, my lord.
Dated 17/12/2024.
Yes, correct, my lord.
Acha. Yes, we have fine.
The operative part, which we like to highlight, that is in page 28, Roman number.
Roman number, acha.
Page 28.
Just a second.
4.
Yes, Roman page 28, yes.
Correct, my lord. So that is the conclusions of the order pass, and in para 2 and 4, we like to highlight that para 2 and 4.
Yes.
If I may, my lord, just go to para 4. May I read, my lord? All the petitioners shall be paid solatium at 30%. They are also entitled to payment of interest at 9% for land and crops value compensation per annum for the first year of acquisition, and thereafter 15 per annum until full payment is met, my lord. Here, my lord, the learned judge has to met, it should be as per section 28 or it should be section 34, my lord. Because the district collector at the time of execution will not understand under what provisions of law this has been paid. If I may kindly take you to section 23 of the LA Act 1894, my lord.
LA.
Your Lordship, if I may intervene at this point, Your Lordship, I'm appearing on behalf of the state respondents, and the notice was issued for the LA appeal on the 2011-2025. Your Lordship, now the state respondents would like to file a cross objection to the LA appeal, Your Lordship. So if I may be accommodated till next week to file my cross objection.
Okay. Okay.
My lord, if I'm allowed, I'll just make 1-2 submissions, and if my lord says yes, we can postpone the matter, then it is okay. Because the main appeal is just for correction as per law, my lord, so that no prejudice may be caused to the respondents.
I do agree with
As
that.
per law, only as per law,
Your
my lord.
Lordship,
He is
we-
saying it is only the law point is only involved, or the section is to incorporate it in the order. Otherwise, it may not be possible on the part of the deputy collector as to this providing those the solatium as well as the other compensation amount.
Yes, Your Lordship. However, the cross
want-
objection will entail a different submission on a different law point as well, Your Lordship. So, if we may be allowed to file the cross objection.
It is
Yes,
up to my
Mr.
lord.
Okay, then let be accommodated her with
1 week's time, Your Lordship. We'll be filing our cross objection by next week.
by next week.
Yes, Your Lordship.
Okay. You are Mr.
Lal Soirama, my lord.
Acha. Hey, listen. He is not a senior advocate. I think. Senior advocate. He is senior. Senior advocate. Acha. So and so the learned counsel for the appellant, and also heard MS এটা নাম তো আছে নহয়, so and so the learned, you are learned additional
No, Your Lordship. I'm government advocate.
government advocate,
Yes, Your
sorry,
Lordship.
government advocate appearing for the respondents. It is submitted by Mr. Laswama that the order only there is some modification of the correction is required in the order passed by the learned additional district and session judge, wherein incorporation of some sections are required, full stop. But in that context, MS so-and-so, the learned government advocate submitted that they need at least 1 week time to file their cross objection, and it may be accommodated accordingly. Next para, considering this submission made by learned government advocate and other aspects of the case, let the matter be listed immediate after 1 week as on a date to be fixed by the registry, enabling the government state respondents to file their cross objection, if any. List accordingly, okay?
Much
Okay,
obliged.
we are
Your Lordship.
accommodating 1 week time. Okay.
Much obliged, Your Lordship.
A similar order can be passed, my lord, with item 8 and 9. Because the same issues.
Same issues are involved here also. Same issues are
Same
involved
facts.
here. Here, in 8 and 9, who is appearing? In both 8 and 9 also? Similar order will be there? Okay then, 8 and 9 will be similar order.
I'm obliged.
Okay.
Item number 10.
Your Lordship, I'm Savita Sarna. I am appearing on behalf of the applicant. This matter was listed for the argument on the application filed by the applicant, deleting their name from this suit, which has been filed by the petitioners. Your Lordship, we were supposed to travel and come physically to put this argument, but due to some administrative reason on the account of client, we were not able to come. So my humble request is, if subject to the convenience of other parties, if we can set up this argument date next week, maybe Tuesday, 7th of April,
7th
or
of
maybe I
April-
can.
7th of April will be convenient for you? Will it be convenient for you on 7th of April?
Yes, for us it is convenient if the opposite parties, because we asked for actually tomorrow also, but one of the counsel was not available when we contacted her yesterday. So next week she said it is convenient, so if other parties are also convenient, we want to come on 7th physically present to put the arguments.
My lord, we have no objections from our side. No objections.
Otherwise, this admission, it is raised only for deleting the name of one private respondent, na? The respondent
no, no.
number, his respondent
Yes.
number 83.
9.
No, his respondent number, whose name you want to get it deleted from the
We-
petitioner. His number is, he is the respondent
Respond-
number.
Respondent
See,
number 9, my
we-
lord.
Respondent number 9.
Respondent number 9, yes,
9, okay.
original suit.
Yes, Japan International
Correct,
Corporation. na?
correct.
Yes, Your
I
Lord.
totally hear.
My lord, they can present their argument like this also, I think. I mean, they can present their argument today also, if they are ready. We have no objection, my lord, for if they
No,
want
but
to.
the question is that most probably on the last week they want to appear physically before the
Physically.
court and to put forward their argument. Due to some reason that may not be possible today. Okay, we are accommodating on 7th of April.
Certainly, my lord.
Okay. In Ayatul Likiba, heard MS S. Sharma, the learned counsel for the applicant, respondent, and also heard. Yes,
My lord, I appear for the respondent number 1 to respondent 82.
respondent 80,
Respondent 1 to 82, my lord.
1 to 82.
Yes, because this is the CMA.
And also the other respondents are also represented by the state councils. As per order dated 10/3/2026, this interlocutory application was listed today for argument, and wherein the physical presence of the learned counsel for the respondent number 9 was supposed to this argument was supposed to be heard in the physical presence of the respondent number 9, but it is submitted by MS Sharma through VC that due to some administrative reason she along with the respondent could not appear physically before this court, and accordingly paid for some accommodation. Considering this submission made by learned counsel for both sides, let the matter be accordingly listed on 7th of April, so and so, and endeavor shall be made to hear the matter and to dispose of accordingly. List accordingly on 7th of so and so. Okay, by listing it. also.
Right,
Obliged.
obliged.
Item number 11.
Lordship, I'm appearing on behalf of my senior Mr. Joniel Tautsong. And Lordship, as per instruction, the TCR has arrived. Paper book may be required in this matter, my lord.
Paper book will be required.
Yes, my lord.
So you are representing all the respondents.
Yes, my lord. And yes, respondent 1.
Her name is so the learned case like additional. You are government advocate, no?
Yes, my lord.
Yes, government advocate for the state appellants. And also heard. You are Mr.
Del mga isa nga. I'm appearing
You
on
are
behalf
appearing
of
on
my
behalf
senior,
of
my senior Mr. Johnny L. Tausong.
so and so, appearing on behalf of Mr. Johnny L. Toshang, the learned counsel for the appellant. TCR has already been received and it is submitted by learned counsel for both the parties that petition registry may be directed to prepare the paper book so that matter may be come for admission hearing on the next date of listing. In view of this, the registry is hereby directed to prepare the paper book and to list the matter accordingly in the admission column immediately after preparation of the same. Okay.
That's obliged.
Item number 12.
My lord, the paper book will be required in this case, my lord.
I've seen in the most of the cases, the prayer is from the council to make preparation of the paper book.
Yes, my lord.
Why is there any problem in dealing with the
Yes, in the
original-
evidence, my lord.
It is written in a vernacular or
Yes, my lord.
oh, that will be the problem.
That is the reason, my lord.
You are the sole respondent, no?
No, no, no.
You are for the
Petition.
oh, sorry, petitioner.
Appellant.
Oh, sorry, appellant. Sole respondent.
The
will
sole
be-
respondent was just here, my lord. He just went out. I believe he's in the restroom, my lord. And I even told him that we will pray for the preparation for paper book.
Okay. You are Mr. Ricky.
J.H. Ricky Lalrotfela.
Hard Mr. J.H. Ricky Lamdrosa, Larfona, the learned counsel for the appellate. None appears on call for the sole respondent. However, it is submitted by learned counsel for the appellate. That the counsel for the respondent was also present before the is also present, who also prayed for preparation of the paper book. This year case record of from lower court has already been lower trial court has already been received. Considering this submission made by learned counsel for the appellant, the registry is hereby directed to prepare the paper book and to list accordingly in the hearing column as on a date to be fixed by the registry immediately after the preparation of the paper book. It has already been admitted, so it will come for final hearing only.
Yes, my lord. Obliged, my lord.
Item number 13.
Your Lordship, this subsequent bail application is filed
The-
after the earlier one is
You are
rejected.
appearing for all the 3, 13, 14, 15, 16, 17? All?
No, my lord. Only
Only in
13, Your
13?
Lordship. 13
Only in
only.
13? Okay.
Yes, Your Lordship.
Yes, what is 13?
This is the subsequent bail application after the earlier one was rejected by the NDSPS Special Court, my lord. The present petitioner is one of the accused persons, and he was arrested on 12th of January 2026. And the charge section is
Case has already been charged sheeted?
not yet, Your Lordship.
Not
My main ground for this bail is non-compliance of section 4748 of BNSS, Your Lordship. And I would like to rely upon one.
No, it's okay.
Yes.
Because sometimes it happens, I don't know what Ms. Linda will submit. And the question is that obviously there may be, as you have submitted that, there may be non-compliance of 4748 is there. So let the case diary be called for.
my lord.
Sometimes it happens that even if there is no the requirement of perusal of the CD may be required. I don't know. Yes.
In this case, it will be required. I'll have to get instructions.
From where it has to come? Which from the
From excise and narcotics in Aizol only, my
in
lord.
Aizol only?
Yes.
Okay, then we can fix a comparatively a short date when it can be
By next Wednesday, I'll try to produce the CD.
by next Wednesday.
Wednesday, Tuesday.
All right, Tuesday also I'll try. I can try.
Next Tuesday also.
Yes, my lord, if possible.
Maybe possible because it is from the Aizol district
Yes.
itself. Hard.
My lord, if it could come upon 9th, that is next Thursday.
All right, Nilo.
Yes, ma'am.
Night. Adipur. First of all. You want to fix it on 9th?
9th, my lord, yes, if possible.
Prior
ma'am.
to that, you can will be or what? No, otherwise 9th will be possible. No issue on that.
Because
I want to give you a shorter date.
Yes.
That's why I'm asking. 9th is okay, then it's okay.
yes, I'm so
Because-
sorry to say I need to be out of station, my lord. That's why.
Okay.
On 7 and 8.
Heard Mr. B. Lal Renga, the learned counsel for the petition, and also heard MS Linda Femble, the learned PP for the state respondent. This is an application under section 483(1) BNSS, read with section 37 NDPS for enlargement of the accused petitioner on bail in connection with excise case number 3/2026 under section 22C, 25 and 29 of the NDPS Act. Next para, it is submitted by Mr. Narenga that this is a subsequent bail application after dismissal of the earlier bail application by the London Special Court. And basically the present petition is filed only on the ground of non-compliance of section 47 and 48 of BNSS. Next para, in that context, the learned PP submitted that case diary will be required to know the fact of the case, and accordingly she submitted that it may be called for. Considering this submission made by learned counsel for good sense, let the case diary be called for fixing 9/4. So it's okay, then we are fixing it on 9/4.
Much obliged, my lord.
Item number 14.
My lord, this bail application has been filed for enlargement of the applicant on bail under section 37 and 483 of the CRPC. The contention is the same as the previous case, my lord. Basically, the violation of section 47 and 48 of the BNSS.
Non-compliance.
Non-compliance, my lord.
Non-compliance.
So, in that regard, my lord, the case diary will have to be called because I have.
Charge sheet.
Yes, it's been charge sheeted, ma.
It's already been charge sheeted.
Yes,
So
ma'am.
we can call for the scan copy of the
Yes.
PCR
Yes.
as well as the case diary. Here also from which where it has to come from the Aizol itself?
No, Lunglei.
Lunglei.
Yes.
Lunglei. So yes, when it can be?
If it's Lunglei, I think it will take some time, my lord. Maybe Friday if possible, or Thursday or Friday.
Friday means 10th.
Yes,
10th of April?
10th of April.
Okay. More or less same order hobo. Hard so and so kori দিব. It was a pending trial in like so and so kori দিব, hard so and so. In relation to so and so, it is submitted by Mr. So and so, the learned counsel for the petition. That case has already been charge sheeted. And your petitioner is in custody since when?
Since the incarceration, except, my lord, there was a 2 months interim bail granted
What? Interim bail was granted
prior to this, yes, my lord.
okay for a considerable period, and he submitted that is non-compliance of 47 and 48 BNSS under the same ground the bail petition has been filed, file poster. বাকিখিনি লিখি দিব same so and so. It will be listed on 10th of April. So we are listing it on 10th of April. We are calling for the scanned copy of the TCI along with the case study.
My lord. I'm obliged.
Item number 15.
Here also, my lord, this is the co-accused.
Who has been out of same FIR or same case?
Same case, my lord.
In 15 also?
Yes, my lord.
Okay then. Same order will be there, okay then?
My lord.
In that case, we are listing it on 10th for 4.
I'm obliged.
16 also you are appearing? No.
No, my lord.
Okay. 16.
Item number 16.
If it pleases your lordship, this is bail matters. Your lordship, the prefix of the case which led to filing of this petition is that on 17 of January 2023, the petitioners along with 2 other co-accused were arrested in connection with the seizure of 503 grams of heroin. And bail petition was submitted in the Learned Child Court, and which was rejected on 10th of December in 2025.
After rejection of your earlier bail application on 10th of December 2025, this is the subsequent bail application.
Yes, your lordship. And your lordship, charge sheet had already been submitted, and out of 11 witnesses, 10 witnesses had been already examined till date.
10 witnesses?
Yes, your lordship.
Oh. Then too, it is a verge of end of the trial, in fact.
But your lordship...
It seems to be. I don't know. There may be others, but if out of 11 numbers of witnesses, 10 has already been examined, then it's a... Anyway, yes, Ms. Linda, I want to submit anything.
My lord, since it's a commercial quantity, I'll have to seek instructions, my lord, in this case. And since I'll have to see whether the trial is almost ending also, my lord. Let me
By
get
that time, the last witness was examined on which date? Can you tell us? As per you, out of 11, 10 witnesses have already been examined. When is the last witness was examined on which date?
Your lordship, so I think...
Do you have any instruction in that regard?
This month, I think, but I don't know the exact date, your lordship.
Okay. Anyway. Heard you are MS?
Vanlal Sandam, your lordship.
Hard MS number from MS Valaisan MB, the learned counsel for the petition. Also heard MS Linda Campbell, the learned PP, appearing for the state respondent. This is an application under section 483 BNSS, radio section 37 BN, the NDPS, bring bail for the accused petitioner who is facing trial in SR number 125 of 2023. In the court of, in which court?
In the NPS.
In the court of NDPS special. In
Yes,
the
sir.
court of NDPS special, Mizoram. It is submitted by her that the present accused petitioner is in custody for a considerable period. And out of 11 numbers of witnesses, 10 numbers of witnesses have already been examined by the prosecution. MS Linda, the learned PP, submitted in this regard that she need to take some instructions and accordingly prayed to call for the scanned copy of the TCM along with the case study. Considering the nature of the offense and submission made by learned PP, let the scanned copy of the TCM along with the case diary be called for from the learned trial court below. When it can
My
be?
lord, let it come up on 10th altogether.
10th. Okay. 10th of April. We're listing it on 10th of April. By that time, the number 11 witness may also be examined. Let us see.
Yes.
Much obliged.
Item 17.
Yes, what is 17?
May it please your lordship.
Yes.
Your lordship, this is a bail application filed under section 483 of BNS read with section 37 of NDNPS Act 1985. Your lordship, the charge sheet had already been laid out by the case IO on date 24 July 2025, and I believe it will be necessary to call for the second copy, the case record.
Same order on the It criminal trial number 24. No. Trial over the petitioner who is an accused in criminal trial number 24 of 2025 assay. In exercise kiba assay to. Likute apnai subidajanok mana hai. To scan copy of the TCR along with the case diary. It is cases already been charged sheeted, na?
Yes. Yeah.
How many witnesses have all examined? Can you tell us any?
There were 6 witnesses, and 2 witnesses were already examined. That is a seizing officer and the civilian witness, and 4
Two
witnesses.
witnesses have already been examined.
Yes.
Okay, let us peruse the case record. If
Yes.
possible, on the part of the court to elders him on bail, then definitely. Okay. When yes, Linda.
My lord,
Can maybe there are
then-
many matters, so can it be on 9th then?
My lord, this is from Colosseum district. I don't know whether it will reach on time or not.
Oh,
This is a different district.
your vacation till when? Reopening day? 11?
Starting from 13th of April.
13.
Huh? No. Yeah. 20 is the reopening.
Yes, 20th is it's reopening.
Oh, you also having Bihu vacation, na? Holiday? Oh, acha. Because 10th is the last working day, but 11, what about 11 is the second Saturday, 12th is Sunday, so on 13 onwards it's a holiday, so 28. So better not to give on 28, let it be on 21st then.
All right.
Because on 28 it may not reach also, okay? It's 21st.
Yes.
Deeply obliged.
What's it? List is over?
Over.
Over. List is over. Hearing I think is loaded. Is there any counsel for hearing? No.
I don't think anyone is present today.
Anyway, okay.